testifying or sharing screens or anything, they can go to the YouTube feed, which is turning on in just a second. And there it is. All right, let's get on the record. This is 2020 CV341259, Dr. Parikh and others against Mr. Thakkar and others. We're here primarily to hear or discuss an emergency motion that was filed, I believe, concerning the Santorini restaurant and pursuit of injunctive relief to freeze that situation, stop pulling equipment out, et cetera. We have a threshold issue that we need to discuss first, which is Mr. Knowles's representation of the 3 restaurants not known as Green Chili's or Euro City Mediterranean. So I'm going to want to hear from both sides briefly about that. I've read the briefs, but I want to work through that a little bit. We have until about 3 o'clock. I'm taking a plea, hopefully, in a case that was supposed to go to trial on Monday, and that's supposed to start around 3. So we've got a couple hours to work through what we can. There always seem to be other matters as well. So if there are other things we need to talk about and you all create time for that, I'm happy to cover that. Again, operating policy in here, if you're speaking and you're on an extended speech, 1, be near a microphone, doesn't matter which one, and 2, it's okay if you take your mask off. In fact, it's easier to hear you if you take your mask off. If you're not talking at this time, or all you're going to say is yes, Judge, or no, keep the masks on, and we will roll that way. So Mr. Cohen, I'm going to start with you just in setting the agenda. We're going to talk a little bit about representation for Euro City Hiram, Euro City 400, and Gateway Rest Group. Is that AKA Santorini? Yes. Okay. We're going to talk about your emergency motion for relief concerning Santorini. Were there other items you wanted to try to get to this afternoon?
That's my agenda for today.
Wow. Okay. Not as ambitious as I thought. I'm all right with that.
I would love to talk about the receivership, and
it will come up in the discussion of how we're handling Santorini. And I've looked into that, and I believe I can address that whenever, but I want to be holistic about how we're working through this. Mr. Knowles, as counsel for some of these moving parts, maybe more, maybe less, were there other things you wanted to talk about today?
No, Your Honor. I believe Mr. Thakkar in his individual capacity may have some issues that he wanted.
Well, he can tell me that because I'm going to ask him next.
But for the entities, we're just responding to Mr. Cohen.
Okay. Mr. Thakkar, how are you?
I'm doing fine, thank you.
Welcome back to the United States.
Thank you.
Everything well in India or not well?
Considering, what the priority, I at least did everything I could to be here.
Okay, well, you're here. Appreciate it. Tell me what you were hoping to cover today.
What I'm hoping to cover in the limited time that I got to review everything is I went through everything, and we have, and I think Mr. Knoll has it on his thing that he can show a proposed order, which essentially takes what Mr. Cohen was contemplating in the proposed order and made some cosmetic changes to basically to communicate our good faith and intent to meet with the spirit of what Mr. Cohen is looking for, at the same time allowing us to continue just normal business and establish some thresholds for the categories that would allow us to function. And essentially look at the facts that have happened relating specifically to Santorini and any other funds that they work on. to show that what happened is a little bit different than what has been laid out.
Okay, and when you say allow us to continue to function, you're referring to the three EuroCity Hiram, EuroCity 400. I thought Gateway Rest Group Santorini's closed. Like I could not go there and buy a sandwich or whatever they sold. But Hiram and 400 are still open. And so when you say have us continue to operate, you're referring to those two restaurants?
Thank you.
Okay. All right. Well, it sounds like what you want to cover will be part of the discussion when we get to Mr. Cohen's motion for the injunctive relief. And it may be that the parties aren't as far apart as one might think based on the tenor of some of the communications. Oh, which reminds me, something that I need to make very clear, and I'll try to say it at the end as well. There has been a fair amount of communication back and forth that funnels through Ms. Niles that doesn't need to funnel through Ms. Niles. For example, if someone has a document that may be filed someday but hasn't been, here, other than a proposed order, obviously you send me a proposed order, but if it's we're going to be filing this motion next week, don't send Ms. Niles a motion you might be filing. And don't use her as a conduit for communications to the other side. And this applies to, I'm calling it three entities here. Mr. Cohen, his clients, Mr. Knowles, his clients, Mr. Thakkar. You are free to email each other all you want. Don't include Ms. Niles on those emails. You reach out to Ms. Niles because you need something from the court. We've got an update for the court. Now, needing something might be, hey, I just got this weird thing from the other side. And Ms. Niles, I think you should see it. And that's fine. I'm not saying don't send her documents, but when I ask her, hey, what's going on, too often she is responding, I'm dealing with emails in the Parikh case. And when I say, well, what kind of emails? They aren't emails that ultimately are requiring her or me to do something. So let's cut her out of that traffic. And please just reach out to her, as I said, when you need something from the court or you got something for the court. That make sense? I'm seeing lots of nodding heads. Good. All right. Let's start with this representation issue. And Mr. Knowles, I'm going to let you start. Let me frame it as I understand it. The management agreements divide authority. They're two members. It's a 50-50 situation. And there may be LLCs in the middle, but it helps me to be simple. We've got Dr. Parikh, we've got Mr. Thakkar, 50-50. The language of these agreements actually say it's 50-50. It's not clear to me they say every decision has to be with a 51% majority. There are cases that point to agreements like that. That's not this agreement. And these management agreements say, by the way, we have two managers. I'm not remembering his name, but he's gone. Some guy who doesn't manage anymore. And the other one's Mr. Thakkar. So the notion that Mr. Thakkar might have the authority to retain counsel for the three defendant restaurants, it doesn't seem to be offensive to the language of the management agreements, but I acknowledge it is not 100% clearly authorized by it because it's not a strained read of the management agreements to say you'd need 51% of the votes of the LLCs to do something like that, to retain counsel, to bring a lawsuit, to do anything that significant. And of course, there's not 51% of the votes. There's two, or it doesn't matter because you don't have both. So it's an interesting issue. I mean that truly. And it's kind of murky, which is probably why it's interesting. But that's how I'm understanding the nature of the dispute. And I actually appreciate both sides of it. But I'm going to let you start, Mr. Knowles, because right now you are seeking, you are representing, you're listed as counsel of record for what I'm calling the defendant LLCs. And I'd like you to tell me briefly why you think that's okay, and okay is the wrong word, why that's authorized by the management agreements. And you're welcome to stay seated and use that microphone. You're welcome to go to the podium. I'm happy either way. You do need to make your microphone have a happy green light on it. There you go.
Thank you, Your Honor. And I apologize. I didn't know we'd be arguing this, so I didn't prepare anything to show you.
You don't need to show, I mean, you've written a brief, I've got the motion, so that's why, I mean, that's how I was able to, maybe poorly, but at least frame the issue. And so I just want you, if there, you could simply say, I rest on my brief. There's nothing wrong with that.
Well, you did summarize it pretty succinctly. The only thing I would point out is that Mr. Thelios and Mr. Thakkar were designated as managers of the three restaurant entities, is what I'll call them. I don't think there's an issue with me representing Green Chili's.
I have not heard anything about that. It is solely what I'm calling the defendant LLCs. And you may have a better name for it, but I'm talking, so we're clear on the record again, Euro City Hiram, Euro City 400, Gateway Rest Group. I'm gonna call that the defendant LLCs. And that's where I've read about the issue that Mr. Cohen is saying. That's not proper because there wasn't a sufficient vote. Mr. Thakkar alone doesn't have the authority to retain counsel for one, two, or all three of those LLCs.
And Your Honor, I know you're well read on the brief, so I won't belabor the point, but simply, Mr. Thelios is out of the picture. So the only remaining manager at this time is Mr. Thakkar. There's been no other manager appointed. The documents, all the operating agreements for those three entities allow the managers or officers to take whatever action is needed to manage the company. It's explicit in the officers section. And Mr. Thakkar exercised that authority to hire an attorney for these essentially defenseless entities. So that's our position, that, and also that, you know, there's a bit of a conflict if you can sue an entity and prevent them from hiring an attorney, and then, you know, Georgia law, the company has to have an attorney.
You're guaranteed a voiceless opponent.
Correct. Yes.
So what in the management agreement in your mind defines managing the business to include hiring lawyers or a firm to represent the business? Because management typically would mean make sure we've got the lamb and the pita and this and that, and do we have the right staff? Are we open? That doesn't exclude hiring lawyers, but that might be less day-to-day management and more, well, let's talk to the executive leadership.
Yes, Your Honor, and I apologize. Again, I didn't know we'd be arguing this. Let me pull this up real quick, and then I will give you our position on that. So in section 6B, it says, any action taken by an officer designated by the members pursuant to authority delegated to such offer shall constitute an act of and serve to bind the company. So, Your Honor, I think any action is pretty broad.
An officer in your mind is the same as the manager, so it would be Thelios or Thakkar?
Well, in that same section, Your Honor, 6B, it says the members may from time to time designate one or more officers with such titles as may be designated by members to act in the name of the company with such authority as may be delegated to such officers by the members.
And that's the creation of the managers.
And in that same section, it says George Thelios and Mr. Thakkar are hereby designated as the company's managers.
Okay, I follow that. So, Mr. Cohen, why does that route in your mind end in a dead end for what Mr. Knowles is doing, as opposed to that's exactly why it was appropriate for Mr. Thakkar as the only remaining manager to, and an officer, as we'd use the term from the management agreement, to bring counsel on board. So answer that question. And how do you work through that conundrum of your client can sue the LLCs, and ensure that they remain literally defenseless. I mean, to the point of defaulting, I guess, because they can't hire a lawyer, they can't file an answer. And so you win, but you're suing yourself. I mean, you please.
Judge, I'll get into this as much or as little as you want me to at this moment,
Medium amount.
but the this not being what you're actually talking about, but the this being receivership,
Oh,
because that I think is the solution to the conundrum, right? But here's what I think the operating agreement says. 6A, the members, and by the way, it always uses the plural of members. So it's not any one member can go out and do whatever they want. It's members. The members shall have exclusive and complete authority and discretion to manage the operations and affairs of the company and to make all decisions regarding the business of the company. That's the entire beachhead. There's nothing left.
right. But then
But
they
then-
can declare these officers.
Yes. It's unclear to me that a manager is an officer. And certainly, by the way, nobody in this room wrote this operating agreement, nor would we, but that happens. But it's not clear that anybody intended or appointed any officers for this company. And nor does section B address, other than for George Chelios with day-to-day operating decisions, what authority out of 6A is being delegated to anybody who's called a manager in 6B. And the only authority that was delegated was day-to-day operating decisions.
Hence my question to Mr. Knowles about there's a difference between these day-to-day operations, getting the pita bread and the whatnot versus, we need to bring a lawyer on board. This is an existential threat to the business.
We're going to hire a lawyer. We're going to file a lawsuit. We're going to shut the restaurant down. We're going to file a bankruptcy. Those are things that require member approval, even if you had managers under the act.
Unless you delegated authority.
Correct. Right. Now, we didn't really argue this, but it's worth mentioning, which is my clients are owners because they bought the entity that Mr. Chelios owned. It's quite possible, given the vagueness of all of this anyway, that my clients stepped into the manager role when they did that. I can't tell you if that happened or not, and I didn't try to. But so I think the better reading of all of this, particularly when it comes to tectonic decisions, is that the members are in control, and the members ought to be able to decide whether to file lawsuits and such and hire lawyers. Now, when we filed this lawsuit, we were very careful, and I thought about the issue that you've raised about the defenseless restaurant entities. We asserted no claims against them. We named them as relief entities only to address, again, the court's concern later that they needed to be in the case if you were to impose a receivership or something of the like. So they are in the case. That's why they're in the case. We've asserted no claims against them or on behalf of those entities. I as easily, I think, could have named them as plaintiffs. I just didn't. And I think I could have acknowledged service or submitted them to the jurisdiction of the court or whatever. But I was trying to be conservative and not overstep when I did that.
Remind me why now those three LLCs are, in your original complaint, are they listed as defendants, but they're relief defendants, or they're not listed at all?
They are listed in the original complaint as relief defendants only.
Okay, and that's they're actually labeled. I'm not doubting you. I'm going to look at
Right.
it. I've never seen that before, but that's to basically put all litigants in the court on notice. There are these parties here, and we don't view them necessarily as liable to us, the plaintiffs, but they will be affected by the outcome of this litigation, and it would be odd not to join them to the litigation.
That's exactly my thought process.
Okay.
And I made up the term relief defendants.
Well, you know what? We may be making some law here that sticks. But one of your points is, Judge, I mean, it's not quite a coin toss, but I just as easily could have put them on the plaintiff's side of the V.
That's right.
Because my client represents half an interest in those. And so they could go either way, but they ought to be in the mix.
We never envisioned a scenario where Thakkar is using those entities to hire a lawyer and assert claims. Right? I mean, that.
Okay, and that gets to my next question, which is what has changed? So your original petition, complaint, does list those 3 LLCs as defendants. Okay, and paragraph 5 says they're included as defendants, so the court will have jurisdiction, but not, they are not notorious scoundrels.
Right.
Okay. What has changed? There's now a counterclaim brought by those LLCs against, I think maybe Mr. Patel.
It's a little fuzzy.
Okay.
How it's written, but my understanding is it's against Mr. Patel. And the counterclaim names Dr. Parikh's name, but I don't think it asserts any claims against him.
Okay. And okay, I follow that. For today, I don't think I need to resolve this, but I wanted, since we were all together, I wanted to give both of the lawyers in the mix, and I'm not ignoring Mr. Thakkar. He is not counsel. He can't be counsel for those LLCs. So
Judge, I will say this, which I started with, which is, I think that the easy resolution to this is the appointment of a receiver.
So you're stealing my thunder, because we're going to pivot now to your motion for emergency relief. Again, I'm tabling this question of representation. So for today, Mr. Knowles, you're free to speak for the LLCs as you see fit. I appreciate there's this issue out here, and I need to resolve it before we go much further, but I don't think I need to resolve it to have a good group discussion, and this will involve Mr. Thakkar, about a means of getting us closer to a finish that doesn't drain everyone financially because they're paying for lawyers or taking time away from going to India to take care of family, et cetera. And I'll start, and again, I'll hear from all three, by giving you a chance, Mr. Cohen, to give the yes answer to the question is, why wouldn't putting a receiver in place to serve as this referee, because we've got this 50-50 intractable divide, not be the right way to maintain things, let businesses keep running, ensure that equipment doesn't go somewhere, or if it does, it's because a neutral is saying, let's sell this because we don't need it. Let's put this into cold storage. Let's protect this from being seized by creditors or thieves or whatever might happen. And it's not someone named Dr. Parikh. It's not someone named Mr. Thakkar, because those two mixing isn't going real well right now.
I would say it could be, but not together, right? I mean, if Mr. Thakkar wanted to buy the restaurants from a receivership, sure. And if Dr. Parikh wanted to buy them from a receivership, sure. Whoever the high bidder is, if that's how it goes.
Right.
Sure. But Judge, yes, the answer to your question is absolutely 100% yes. A receiver would be a good solution, although you did raise the issue of expense, and receiverships are notoriously expensive. They're horrible. And, you know, that just may be the burden that everybody has to bear here.
Well, put differently, receiverships are good prods to prompt resolution
That happens too.
because they are expensive, and people realize the way to have no more receiver is to resolve our differences. A buys out B, B buys out A, they sell, split the pot, whatever it is. Yes, there's a cost, but there's often a positive outcome flowing from that cost.
We are a year and a week or two into all of this. And it's been chaos the entire time. Until earlier this morning, we didn't get the financial information that we were supposed to have been receiving on a regular basis since the last hearing. When I looked quickly at what I received this morning, I thought, well, those numbers are just silly. For example, on the bankruptcy petition, there's a $350,000 debt that Mr. Thakkar, on behalf of Gateway, listed for the rent that's past due. You won't see any number for the past due rent on the financials that we received this morning. That's the biggest debt. I don't know what else is wrong with these numbers, but I know they're not right. I did see some positives that should be negatives, probably, and negatives that should be positives, probably, and things that were added that should have been subtracted. I don't know. Judge, on May 12th, two things happened. We received first at noon, plus or minus a few minutes in either direction, and then at 2, plus or minus a few minutes in either direction, an original and then an amended letter telling us very little other than,
This is May 12th of this year.
yes.
Okay.
Other than Dr. Parikh needs to put $200,000 into Lewis Cohen's trust account by 5 p.m., either 5 hours or 3 hours after the letter, or else we'll assume that you're not doing what you're supposed to do. We didn't have any financials. We didn't have any inkling that they were about to close the rest Santorini. We didn't have any idea what that related to. We knew we weren't inclined to give Mr. Thakkar control of another $200,000. And later that evening, Mr. Thakkar and whoever closed the restaurant and removed most, if not all, of the property, personal property.
You say personal property. I know there's been some back and forth about equipment. Is that what you mean by personal property?
It is.
So not a fixture like a stool, but an oven.
I think there were many fixtures that were removed,
Okay.
and I could show you the video. It's if you haven't.
If we
already
need
looked
to
at
get
it.
there, we get there. I don't know that we need to, but when you say personal property, I think of Mr. Thakkar leaves with his wallet, which would be okay by me that he leaves with his wallet.
So let me say real property, personal property, and fixtures.
Okay.
Okay. Fixtures and personal property, mostly gone. What
Gone and you have no idea where they are?
we do
or-
now,
Okay, because I thought Mr. Thakkar had said, here's where things are.
not
And-
then.
No, not on May 12th or May 13th, but since then. And
Yes.
it's helpful to get a little background, but the drama of what happened on May 12th or 13th may be less dramatic now if you know where things are and this has happened and that. It doesn't
Yeah.
cure the situation, but it makes it less dramatic.
So the next morning, of course, we get a letter from the landlord council saying that that's happened. That there's a sign on the door that says renovation, which isn't true, and he's removing it. And that's what prompted the filing of the emergency motion for injunctive relief. And Judge, I want to, if I can, start with the order, which I submitted as our Exhibit 15.
Let me get to the exhibits. And Mr. Knowles and Mr. Thakkar, you have these exhibits?
Yes, Your Honor.
Okay.
I'll share them with Mr. Thakkar.
Thank you. Wrong file. Exhibit 15?
Yes.
Okay.
the proposed order.
Got it. It's only 3 pages.
That's right.
All right.
And Your Honor, in my mind, again, I thought, well, this is what's happened. What's the best way to bring some order to the chaos? And so this is the order I proposed. And essentially it's Mr. Thakkar and the defendants and the affiliates and the agents, et cetera, are enjoined and prohibited from directly or indirectly moving, spending, disposing, or transferring any and all funds and property of those restaurant entities. And then.
So this is the order that Mr. Thakkar was referring to earlier today, saying, hey, we've got some cosmetic changes. I don't need you to agree whether they're cosmetic or not, but your understanding is that this has gotten some traction with the other side now.
As of a few moments ago, yes.
Okay, but I'll take it. It has happened. Okay, so this is the starting point.
Yes.
Okay,
And then paragraphs 2 and 3, we're worried about small business administration funds and PPP money and IDIL money and all of that. And we want to lock that down. And we wanted disclosure of the property that was removed from Santorini. We've now had that. It's not pretty, but we've seen it. And we wanted the defendants to be enjoined from moving those items from that location during the pendency of the litigation, because we want to make sure we know where they are.
sure. So this is sort of a receiver-esque in nature, but it lacks I'm guessing this is one of Mr. Thacker's concerns. It lacks the element of discretion of, well, but we will let certain other things happen. It's just protective, but it's not forward-looking in the sense of, in the meantime, let's keep these businesses going.
Right. Mr. Thakkar, and again, I literally saw this order for the first time less than 5 minutes before you came on the bench.
It was good I was late then. I gave you
Yes.
time to read it.
I did. And what I saw is that it started with the motion is denied, so we would object to that. And then, but what I did see is it proposes a lot of the relief that's in here. But Mr. Thakkar talks about being able to run the restaurants and having some ability to spend money in the normal course. And I don't think we have any objection to that, but we do want to have access, and I don't want to give him any spending authority. I want two-party approval on everything. We certainly want to keep the restaurants running.
But if he doesn't have spending authority, how do you keep the restaurants running if there's not a receiver?
Well, this would give him authority to spend money with this being my proposed order with our approval. So long as we get two-party approval, which is not unusual in a two-person or two-entity business, right?
Okay, so it's not you're enjoined from, it's if you're going to spend, there's no spending threshold. And so that may be something to discuss of, well, maybe it should be a dollar amount below which no one needs to get a double signature, above which, yes, there needs to be a double signature, but I understand your point.
Yes. And I could grind through the balance. You know, I think here today with notice, we're not at the emergency temporary restraining order stage of the three-step injunction process. I think we're at the preliminary injunction stage.
Right.
And the standard's different. And I think it's just balancing the good and the bad to see if it makes sense. And given how limited the relief is that we've requested, I think it's a pretty easy calculation, at least in my mind.
And the reason why it's plaintiffs plural is because Euro City Mediterranean is the actual stakeholder in the three restaurants, but then Dr. Parikh is the controlling member of Euro City.
Well, to further complicate matters, Dr. Parikh is in this lawsuit as a plaintiff only because of the promissory notes, to be purely technical.
Mhm.
Euro City Mediterranean is owned by an LLC called Nirvana.
Mhm.
And Nirvana is in turn owned by Dr.
By
Parikh's
Mr.
son.
Patel. Okay. And Nirav Parikh.
Correct.
Okay. I've got that in my notes here. I'm just flagging it, not because I'm accepting the proposed order yet, but I want to avoid, hey, it says plaintiffs, and this doesn't have Dr. Parikh's signature on it. But it may not need it if really the ownership of the LLCs is 50% Eurocity Mediterranean, which would mean, I assume Dr. Parikh's son signature would be enough because he's by far the majority stakeholder in Nirvana.
And Judge, I think our preference would be, and I asked Dr. Parikh in the moment I had before we started, I said, if we get into this discussion about signatory authority and we're going to make it a very small limit, spending limit, or no spending limit at all without authority, you're going to have somebody on your side that's available to approve things. Who will that be? He said that would be him,
It would be Dr. Parikh.
Dr. Parikh.
It's his call. Okay. Because if we are going to enter something, I think it needs to be more explicit than plaintiffs or defendants. This is the person. And if this person isn't available within a certain window, here's the person who is the
Plan B.
Yeah, the beneficiary of that authority, the backup. And so that might be Mr. Patel, it might be Nirav Parikh. I don't care who it is, but I'm envisioning something that has as many fail safes as possible. So you don't get dragged in, which then means I get dragged in, solely that we can get enough of the sauce for the euros.
Yes.
Okay.
Thank you. And unless you have questions, I'll.
You don't have to, you can pause now because I want to hear from Mr. Knowles and Mr. Thakkar if he's going to chime in as well. Why this isn't a good idea, given how rocky things have been over the past few months. And when I say this, it may be an amended form of the proposed order, but something that brings back the other member's voice in meaningful decisions in the operation of the 3 restaurants. That to me seems like an appropriate remedy at this time. I'm very open as to what that looks like. One vision is a receiver. It's an expensive vision. Another would be that there's the ratification from the other member of significant decisions. So I'd like to hear from you first, Mr. Knowles, as to what you think the right way is to move forward with this. And maybe what some of the amendments are that you have in mind to the framework that Mr. Cohen has very helpfully fleshed out in the proposed order.
Thank you.
Thank you, Your Honor. And fortunately for everybody's schedule, I think our vision of the proposed order incorporates a lot of what you were just talking about. Our concern on the defense side is the efficient operations of the restaurant. And I assume that same is true of plaintiffs. And the way that the plaintiff's proposed order is written, I think that would, that they could veto any transaction. That's going to freeze things up. We know these parties are contentious.
Well, and beyond vetoing, you've
problem.
got just the, every once in a while, you know what, we're out of ketchup. Go to Kroger and get it. You know what? Normally we get it through the big wholesaler and all that, but we need ketchup. Go get a bottle of ketchup. I can't find Dr. Parikh. I can't get ketchup. A $2.59 bottle of ketchup. So clearly there needs to be a threshold in here, and maybe a stopwatch of if we propound the request, there needs to be a yes or a no within X hours or days. Silence is yes. So that it wouldn't be, oh, Dr. Parikh is unavailable and the backup is unavailable. And so we're stuck. We can't buy ketchup because we can't find the guy. Not the business's problem. Keep going.
I think you're going to love our proposed order.
Maybe I'll love both.
If I may ask my associate who's on Zoom to share that on the screen. We prepared it in the form of a red line with plaintiff's proposed order.
Okay.
And, we understand there's no trust here and that they need some assurances. We disagree with the lack of trust, but it's an unfortunate fact. So we prepared this red line, and as Mr. Cohen pointed out, due to Mr. Thakkar being out of the country, and you can leave it on page 1 there, Jason, for now. But our prep was,
Let me interrupt you for 1 second.
yes.
Just so I'm where you all are, Mr. Cohen, what I'm looking at now on the screen is what you got 5 minutes before we start. You said you got something just before we started. That's this?
I think so.
Yeah,
Or is there yet another thing out there?
It's not, although I'll tell you, it's not identical. I don't
Is it
know.
not? As
It
Mr.
could just be how it renders the red line.
Okay.
Okay.
Yeah.
Is along the lines of what you received just before we started. Okay, I just want to make sure there's not that Mr. Thacker can get up and say, well, I've got one that's green lined and is different.
It should
Okay.
be the same, and if it's not, that's a technical problem or
Okay,
something.
substantively, it ought to be the same.
Yes, sure.
Okay.
And I apologize, Mr. Thacker was out of the country, so our prep time and his capacity as an agent for the entities was compressed. But in the course of that and reviewing Mr. Cohen's proposed order, I said, what is objectionable about this? And did present to Mr. Cohen a little short notice, so I apologize for that. As he pointed out, we made some cosmetic changes. We would prefer if it was just a consent order based on an agreement and, not an injunction that seems like it's some kind of punitive thing. But Jason, if you would scroll down to the second page, number 1 there, Judge, we're trying to do what you said, essentially, which is set some amount, and there's going to be a disagreement on the amount, I'm sure, but, decisions can be made under this amount, and because somebody needs to run the restaurant. And if there's something that exceeds that amount, down here in Part B, our defendants, Part A, defendants will communicate that to plaintiffs 48 business hours. So we're not going to email on Friday night and expect them to make a decision over the weekend that they're about to make a prohibited transfer, which would be in excess of a certain amount or the aggregate of a certain amount in any 1 month. Plaintiffs will then have 24 business hours after that to object.
What's a business hour?
Just
I'm
during
familiar with
business.
business days, Monday through Friday, but a business hour, is that a different from like a
Yes,
meat hour?
we could change it to 2 business days and 1 business day since it's
You
48.
can do it however you want. I just wanted to know, if these restaurants are open 7 days a week, then maybe it's just 48 hours. And we don't need to fine tune it now. I just want to make sure I understand the proposal. I'm gonna let Mr. Cohen ask questions as well. But business hours, not some funny kind of like it's only 48 minutes because the remaining 12 are not insured or something.
Actually, it was something I was proposing as a benefit to the plaintiffs. So if we emailed on Friday at 5 o'clock, they have until Tuesday. We're not making them have.
Got it.
If that was
You don't
in
count
our
weekend
code,
days, is
correct.
what you're doing. Okay.
Sorry about that. If that's not apparent from what we were trying to do, we could correct that.
Okay.
So, we communicate, we're about to make this prohibited transfer, give them 48 hours notice. They object within 24 hours or business hours or 1 business day. If there is an objection, this might be the part you don't like, Your Honor, but we would email the court and say, we have an impasse here, and we would describe, when we need to make this expenditure and what's going to be the consequence if we don't make it, and try to get a rule, some kind of guidance from the court, whether it's allowed. Jason, would you scroll down a little more? And then in Part D, notwithstanding the foregoing, we listed out, the landlord and payroll and 3 of the top suppliers as being exempt from the single transaction or aggregate transaction limitation. Just so something in an excessive payroll, if you total it all up, is going to be a fairly sizable thing, but it's something that has to happen on a routine basis. Same thing with the rent payments, Your Honor. So that's our proposed order. As far as would you like me to continue with that or answer any questions? Or
No, I'm following it. So, and I take it that the Roman numerals that are not payroll expenses, they're what you just said. It's rent, or it makes sense. Restaurant Depot is where you get a bunch of supplies from, and that might be one where there doesn't have to be the blessing of a $6,000 bill, because you're not going to get something funky from Restaurant Depot that you can't use at a restaurant.
Correct.
Okay.
Yes, Your Honor. And Mr. Thacker can speak to the details on this, but my understanding is item 1DI is the landlord for one of the operational restaurants. Double I is the other landlord. Payroll expenses is obviously obvious. And then the last three there are the top suppliers.
Okay.
That's our proposal. Jason, can you scroll down to see if we made any? The other changes again are cosmetic. We think I can ask my associate to email that to Ms. Niles if you want to review it in closer detail. But again, we would prefer it's not punitive, more of a we're working together here, answering your questions and just trying to run the right.
Yeah, I don't mean whatever label we put on it. I am not at the point of being comfortable designating anything as punitive. I've read the pleadings and a pox on both the houses. Everyone is evil in this case if you read everything and believe everything. I'm looking for stability and an ability for the businesses to move forward under their current ownership structure. That structure may need to change. That's not for me to sort out right now. So I'm not going to get in the middle, and I hope the two sides wouldn't get in the middle of, do we call it an injunction or an order? If it provides the level of protection that makes Mr. Cohen's clients comfortable, we can call it the goose that laid a golden egg. It doesn't matter. If it also provides the operational flexibility that the businesses aren't so hamstrung that ultimately Mr. Thakkar says, I can't make money off this because we can't run them. And that is not something I should get in the middle of, because that's actually leaning on the scales one way to make the business situation unfavorable to one of the co-equals. So that's why I like this approach. I don't know about the specifics, and I want to give Mr. Cohen and his clients a chance to digest all that. But I think there does need to be some flexibility baked into what was initially proposed, which this does. It may be too much flexibility. Ultimately, I may need to mediate that. If the pushback is the cutoff should be 2,000 and you're insistent, Mr. Knowles, that it should be 4,000, I'll resolve that. That's fine. What I'm not good at resolving is there another hole that ought to be plugged? Is there a little more give? Is United Distributors, you know what that one is, but the other one, PFG Milton, is that actually Mr. Thacker's brother's company? Maybe that's not one where there should be unlimited expenses. Money could flow that way. That's where Mr. Cohen and his clients can weigh in. I'm encouraged by this. I don't know that what's on our screen right now is the final answer, but I think it is an improved answer to the answer. And I appreciate people proposing answers now. We need to be getting in that direction. I think Mr. Cohen had a wise start to this, but again, I can't comment on the specifics, but structurally, I think these are the right changes to make to it, because that's what I would have a receiver do anyways. You got to be able to run the place. This doesn't impose the cost of a receiver. So if it can bake in sufficient protections for Dr. Parikh, or more accurately, EuroCity Mediterranean, that seems like a healthy way to maintain an operational status quo until we get to the bottom of all the litigation as to who owes whom what, and is there a way to extricate one of the two partners from this situation? So I will hear from you, Mr. Cohen, in a minute. Did you have anything more you wanted to add, Mr. Knowles?
Your Honor, we anticipate there'd be some back and forth about the amounts.
Yep.
The idea, we don't want to have to come back to the court too much. So that'll be.
I don't think anyone wants that.
They want to speak to.
Well, I'm going to ask him next.
Numbers come from.
Because it's tripartite, and today isn't the right forum, or this hearing isn't the right forum to get it tightened exactly. But you guys are lawyers, and you can ping it back and forth. Like I said, the areas where there's an impasse, I'm happy to mediate that. Hopefully there are lots of areas where there's not an impasse, and that folks focus on the important thing, whether we call it an injunction or an order or what. That hopefully that's not what bogs people down, unless there's a good legal reason for it, and I'll be persuaded by that. So let me see if Mr. Thakkar has anything he wants to add. You don't need to repeat anything Mr. Knowles said. I can read this, and you don't need to justify any of it to me, because I'll be real clear. What I plan to do is give Mr. Cohen time to counteroffer my term, not anyone else's, to the marked up version, because I think it represents movement in the direction that I'd want to go anyway. But I want to make sure they have time to think about that. So with that said,
I
Mr.
do
Thacker?
have a few comments. Sorry.
Before he moves on, Your Honor, do you want me to speak to the actual motion, or do you want to talk about this proposed order first and then I come back up? Or would you like, my presentation on the motion is very short if you want to just go ahead.
So you're welcome to say more. My understanding was that these edits to the proposed order were in some respects the practical impact of your response to the motion, because you've actually said, hey, this might work for us. If you don't think it's justified at all, I figured you wouldn't have invested in that.
I appreciate the opportunity to clarify, Your Honor.
Sure.
This is our attempt at a compromise
Mhm.
with the understanding of what their concerns are and what our concerns are, which, I think is always the best approach. Absent a compromise, though, we do think that it would be inappropriate to grant the motion for several reasons. I was glad to hear Mr. Cohen acknowledge the expense of the receiver. I think sometimes people try to brush over that. But he stole my thunder on the Solomon split the baby argument. So, but it's somebody's got to run it, and it would be extraordinary to intervene, and it would not be maintaining the status quo to interrupt who is currently managing the entities. There needs to be guardrails, but granting an extraordinary relief injunction would be problematic for several reasons. So, Your Honor, there's no grave and impending danger. Mr. Thacker is probably going to speak to this. What he did with regard to Santorini was in the best interest of that entity. They were going to get kicked out. These restaurants have been hit hard by COVID, and unfortunately that one was going to close. He stepped in to preserve the assets. Mr. Cohen's been allowed to review the assets. And so that can't be the basis for grave impending harm is our position. And furthermore, Your Honor, the injunction, the harm of the injunction interrupting the current operations of these businesses, which are in a weakened financial state due to COVID, would outweigh the harm, which is just the plaintiff's need for a constant stream of real-time information. Finally, Your Honor, all of this, particularly the Santorini property that's being held in storage, could be addressed by monetary damages, which would rule out an injunction and also a receiver. So absent a compromise, we would ask that the court deny the motion, but we're happy to hold and speak to Mr. Cohen about how we can work this out. Mr. Thacker is going to have some presentations to fill out the factual basis for some of my legal arguments that I just made, including what happened with Santorini and why that's not shouldn't be considered some grave impending threat for the other restaurants.
Okay, so thank you for sharing that. I guess what I'd like to hear from Mr. Thacker right now is limited just to anything he wants to add about the proposed changes to Mr. Cohen's order. And then I'm going to want to hear whether Mr. Cohen thinks there is still light out there and that there may be a middle ground that could be reached with a proposed order. Because if the answer is yes, then we don't need to spend time today going back and forth about Santorini and real-time information, of which there seems to be very little flowing right now. Someday we may need to get through that, but if there is a workable solution to the concerns that Mr. Cohen has raised in the form of an order looking somewhat like your amended version, that's where I think we should direct our energies. And so I think that's where we're going to stay for right now. So Mr. Thacker, if there's anything you want to add about the proposal Mr. Knowles shared, I'm happy to hear about that, but I'm going to ask you to hold off on a presentation about, hey, here's why I did what I did at Santorini, and look, the equipment's looking good in cold storage. That we may not need to go there today.
And I appreciate that, Your Honor. The only reason I wanted to do that, you have an urge, and I think we brought it up last time, is that accusations keep flowing in every email or every motion I get. even doubted that I went to India. So I asked you the question, Your Honor. I say, is he allowed to accuse me all the time? And I don't want to get into mudslinging. So I would rather, when I sat down with Mr. Knowles, I said, let's focus on a solution. Let's focus on what he has proposed, along with just clarifying to the court that, and you're right, it is for a different day, because once I start, there is no stop.
I've met you before in this case, so that's why I'm asking you to do what you said, which is let's focus on the solution right now. I appreciate your desire to try to, in your mind, set the record straight. It didn't start out real well when, and I quoted from it real briefly, where on the second page of Mr. Cohen's complaint, the very first document filed in this case, you're referred to as a notorious scoundrel. So if I were you, I'd be kind of frustrated by that and may want to clear my name. If it's clearable, I don't know. Maybe you are a notorious scoundrel. I don't know. But those are tough words for paragraph 4 in a complaint. And I'll acknowledge that it hasn't necessarily improved since then, as the sides have lobbed things back and forth through Ms. Niles, which you won't do anymore. So let's stay focused on a possible solution, whether it's a solution that keeps us stable till we resolve the case, or it's a solution that blossoms into, here's how we resolve this litigation.
The only caveat is, Your Honor, is I didn't come prepared to address the receiver issue. I came prepared to address the issue of how can we find a workable solution.
And that's what I want you to talk about.
So I'm going to focus on that, Your Honor. But key point is that they have not put in a dollar from day one. From the day when we took over, it's a very important fact, because as you factor in the proposed order, one needs to think about how and when they will be asked to contribute. But as of today, they were given one opportunity, they did not. But from that day on, they have complained, but they have not provided us even $1 of support.
Okay, but we've got the management agreements that means it's a 50-50 situation, and there was whatever investment was required to create that equal partnership. The fact remains we're dealing with an equal partnership for all 3 of the LLCs, and whether your side of the partnership has contributed more or not long-term is something that needs to be worked through. But on a day-to-day decision-making basis, you don't get a larger say in the way business is operated, because in your mind, you've contributed more sweat equity, capital, whatever it is. You may be 100% correct that you've done that, but here we are faced with a management agreement where it takes 2, not 1.
And this management agreement was again created by Giro City Mediterranean, just so, before they start throwing. And secondly, even the accounting is important, because it was brought up and not related to the order, but it will come into play. These accountants were selected by Giro City Mediterranean before Mr. Thakkar took over in 2020, May 1. So they have been providing the accounting from day one. The reason the delay is when I spoke to them even today, they said essentially the members of Giro City Mediterranean used to directly input into the QuickBooks. Since you took over, you elected to have us do everything. And the reason I did that, because it would be auditable and we could track any changes back to the source. So that was one of the reasons why the numbers don't match, because all the changes, and that's a topic for a different day.
It is.
But on the other hand, I just want to stress all the things that I said, that it is relevant as you make your decision for us going forward, is I intend to honor the integrity of the process. Whatever we agree upon, the thresholds that we have put are after careful thinking, and I'm happy to be challenged and address that issue, is essentially we have, this is not just repeating, but emphasizing, is we have payroll, doesn't allow me to pay myself. Food, the main food suppliers as of today. Then we have, rent and utilities. Those are the main expenses that we have to agree on thresholds. Decision-making, if we have to run to the court every time, $1,000 and $500 will never happen, practically. That's my final comment to this, is that the thresholds we can discuss. If there are any specific concerns, We have attempted to incorporate that by saying any payroll to Thakkar is excluded. It doesn't happen. And it's not been happening either. And so with that being said, I'm happy to address any specific concerns on the proposed order. But the objective is for these restaurants to be able to function on a day-to-day basis. That's
Got it. Just getting the other document back up. All right, Mr. Cohen. I don't want to hear about whether Eurocity Mediterranean has contributed capital or not. That's a topic for another day. I want to know how you think we could most productively move forward now that there's what, again, I'm calling the counter offer. I think it makes your proposed order less of a blunt tool and it makes it a sharper, more precise tool. But it needs to do two things, at least the two that are obvious to me: protect your client, allow the businesses not to be strangled by indecision. And so that's why I thought some of the amendments moved us in that direction. And I'm not commenting on whether it's the right dollar threshold or those are the right vendors. I have no idea. But structurally, that seemed like we're getting closer to sort of a pseudo receiver, in that we know big things won't happen without your clients having an opportunity to exercise their 50% input on that.
Judge, I'll just point out a couple of things. The amounts of money that they want to have discretion over in this proposed order, that's all the money that flows in a month. So we would affect, if we were to enter that order, my clients would have no input. Your issue about ketchup is perfect, right? That happens. That's real life. The solution to that is a $500 slush fund or $1,000, petty cash. And then if you have that come up, you go buy the ketchup, you put the receipt in the drawer. But and right or wrong, we are very concerned with Mr. Thakkar funneling money to himself through other people, through other entities. He goes to Restaurant Depot, he buys something for a different restaurant or a different business or what. How are we going to know that? We're never going to know. And so we want to lock down the money. Property, he's got in here that he could move up to $4,000 of property. We don't want him to be able to move any property. That doesn't happen on an emergency basis, right? So, and I think you might have some experience running businesses. I've been running a law firm for 10 years and I've run businesses outside of that. I've never one time had, literally not one, an occasion where in the case of my law firm, my legal assistant couldn't get approval to spend money that she needs to spend within an hour. So I would just say, I think my order is much closer because it does, each provision says, unless approved by the plaintiffs, and maybe instead of the plaintiffs, it should say Dr. Parikh. And then we put some petty cash aside. And I think we've got everything everybody needs to run very smoothly, but with less panic, less chaos, more control.
So here's my suggestion. You are a little further apart than I thought you might be, but I also appreciate you are reacting on the fly to the amendments.
Yes.
Whether the middle ground you try to reach on behalf of your clients, Mr. Cohen, is to create a reserve fund to address the catch up, or it's a broken window or something that is needs to be dealt with right away. And it's silly to try to get someone on the phone. You're going to have your counter proposal. It strikes me that something missing from your proposed order is a deadline. I appreciate you saying, never in my career has it been hard for my secretary to reach me to approve something in my firm. but you and your secretary are aligned, I hope.
Yes,
These two gentlemen are not aligned.
no objection.
And
24
so
hours.
you don't need to solve it right now, but that would need to be baked in. I mean, that was one of the, I thought, important structural changes that Mr. Knowles suggested so that nothing can be held hostage. I'm not interested in entering an order that would enable your client intentionally or otherwise to strangle the businesses, right? And I appreciate the business judgment rule and all that. This is a bad development. No, it's not a bad development? Okay, you got the quitter with you. All right. It's a gentleman who has the murder trial that starts on Monday. That has been distracting me today. Is it urgent or?
It's an order. Not related with the deputy.
Okay, great. We're taking a plea at 3. If you want to just come back, if it can wait till 3, we're taking a plea. Ms. Hall, I don't know if this will be virtual or not, but I'll be putting on my criminal hat at 3. Why don't you leave it with her? If you come back at 3, this is not on the record, by the way. Thanks. I've been getting some flack about, I'm not comfortable with a 4-defendant trial. It's still a 2-defendant trial?
3, but I'm hoping for 2.
Okay.
I'll know shortly.
We are setting up 1D right now as a 2-defendant jury selection. 3-defendant, 1D, we could fit it. It'll be hard to fit 3 defendants in here. Just keeping that in mind. And given what I'm aware of what the charges are on the other 2 defendants, hopefully you can always sever, but who knows? We'll see. I just was surprised by Mr. King's email because there's nothing new. And that struck me as I just don't want to go to trial, but I don't want to get any more substantive because he's not here.
I agree with you.
All right, so I'll look at your order. Just know we're doing criminal at 3.
Yes, sir.
Okay,
Thank you.
sure. I apologize, Mr. Cohen. That represents my entire next week. You get my concern. It's that I wouldn't want to inadvertently empower your client to resolve the case in his favor because I signed an order that was meant to provide relief, but ultimately strangle the businesses. So that's why there does need to be some type of time frame. And you have a different approach to the other one, which is, yes, there needs to be a prompt response, but also there ought not to need to be a response for the bottle of ketchup. And the rainy day fund addresses that. It's an approach. So here's what I'm suggesting, and that would be you take the time you think is reasonable, with everyone knowing that I'm anxious to get something in place along the lines of what you both have been talking, all 3 of you have been talking about. But if you can respond to Mr. Knowles's proposal with your concerns and suggested responses, and then ultimately, if you've had maybe one more round of exchanges, it doesn't sound like there will be an agreed upon single version. Submit the 2 versions to Ms. Niles and I will reconcile them. But I do intend to enter something based on everything I have read in the case file as I understand the situation to be. That is not me deciding anyone is a scoundrel at all. It is me deciding that that is the most productive way to ensure that the businesses can keep running, but in a way that respects the management structure, the 50-50, I should say ownership structure, because the management structure is Mr. Thakkar manages them. But the ownership structure is not that Mr. Thakkar owns them. He has a co-equal partner who ought to have a say in things such as perhaps do the 3 restaurants have a lawyer? Does that approach work for you, Mr. Cohen? Maybe one more round of back and forth with Mr. Knowles and Mr. Thakkar, obviously. If you all don't quite get fully aligned, then there'll be 2 versions of an order, and I'll figure out the way I am going to bring those together.
Yes.
Okay, Mr. Knowles, does that work for you?
Yes, Your Honor. We're happy to do that. The only thing I would add is that, we are fighting about whether Mr. Thacker's designation as manager allows them to hire an attorney, but I would say it definitely allows them to run the restaurants. And so our goal with the proposed compromise would be
To let him to do that. I agree.
Come back to you or, but at the same time, give him reasonable oversight so that he knows we're not doing anything,
But it's run the restaurants consistent with honoring the ownership structure as well. So that's why I think that building in, there has to be a response within a certain amount of time. And whether it's spending limits or a rainy day fund, we get much closer to the day-to-day operations are not affected by that, but more significant decisions. How much money is going to flow this way or that? What are we doing with the deep fryer that costs $15,000? That's the kind of decision that under present circumstances, I'm not troubled requiring there being input from both of the owners.
Judge, at the risk of making everyone's head explode, short of a receiver who would hire a lawyer and you'd have all the extra layers of expense, an easy solution. Look, Chuck Thakkar is not in there running these restaurants, right? He's not there making gyro sandwiches.
I don't know. I know your client is not. Obviously, Mr. Thakkar was in India for a while, but I don't know if I went to
He's not.
Euro City Hiram on the right day. There's Mr. Thakkar with one of those sort of chevron-y hats and like, hey, I'd like the.
And an easy solution would be to just hire a real restaurant manager for each restaurant and let that person be in control of the money with reporting responsibilities to both owners.
Well, that may be where you all get, but that's not where we are now. And that is a little bit bigger leap from your proposal. It's a less expensive leap than a receiver, maybe. One receiver, 3 managers, or 2 managers since Santorini is closed. But I understand your point.
It's not like he's doing a good job. He suggests without saying that he's putting money in. I don't think he is. I think he's taking money out. But, one of them is shut down. The other 2 they have not distributed any money to any owners, or at least not to my clients.
Right. So I'm not aware of a lot of restaurants that are making people a lot of money right now.
Actually, I think a lot are doing really well right now.
Well,
It's shocking.
okay. I guess it depends which stories you read.
Like real estate, it's booming.
Yeah. I don't know that that's the universal trend with restaurants right now, but either way, it may be that your proposal, which is short of a receiver, but is beyond what we're currently kicking around, is the natural evolution of things. And I would think eventually Mr. Thakkar would say, this is too much a headache. And so let's get these managers here, and I'm in it for the money. I don't run the businesses. I don't know. I haven't given him a chance yet, and it's been purposeful to lay out, here is my version of events. In the same way that, other than on paper, you really haven't been given that opportunity either. You've provided me more than enough paper. And so I have a pretty clear understanding of the contentions, and that's what they remain, because we haven't had any evidentiary hearings. And it is based on my review of the contentions that I do believe that the status quo isn't an equitable solution for Euro City Mediterranean. And that's why I am going to require there to be some change. Right now, that incremental change is along the lines of what both sides have said. I think it needs to be more flexible than Mr. Cohen's original proposal. And he hasn't said no to that. He said, you're right, there does need to be some discretion in terms of some expenditures, and there does need to be a limit or framework for responding to requests that are more substantive than we need more lettuce. And I think both sides are heading in that direction. They may not meet. I'd be shocked if you met, but you're moving towards each other. And that's a different feel in this case. So I don't know that you had finished saying what you were saying. Mr. Cohen popped back up, and he had that, he was going to make our heads explode. It didn't, fortunately.
That's all I have, Your Honor, but I'd say don't sell Mr. Cohen and I short, maybe we can get with it.
Okay, I'm happy to be surprised.
And I will say Mr. Cracker had had a lot that he was planning to say, but.
I know he wanted 7 or 8 hours, but that wasn't happening today. Mr. Thakkar, what else do you want to say?
And the only reason I'm bringing that up is in response to what Mr. Cohen said, is I would have loved the opportunity to bring in the other side. And we have affidavits on file that both, if they call me a scoundrel, I'll leave it at that. I'm going to rise above it. But Mr. Patel has been on an affidavit from employees of the old group, has been seen stealing. Dr. Parikh has been seen stealing, okay?
Okay, so now you're going where you said you weren't going to go.
So
And
we
and
wanna
like I
bring-
said,
Yeah, we want to bring in outsider. We put the controls in place, make sure no money goes anywhere. All of the controls that they need to make sure no money is going sideways, I'm comfortable with.
okay.
But we
Well-
need to bring in somebody else at some point of time, no question about it.
Well, then you guys are a lot closer than I thought, since that's Mr. Cohen's steady drumbeat. And maybe you'll get there. It's not uncommon. I don't know why it's restaurants, but this is maybe my 4th or 5th restaurant case where people went in 50-50, and boy, that didn't end well. And the way most of those have ended is I'm bringing in someone else to run this, receiver, manager, call it what you will. And then people realize what that was going to cost them, and one side sold out to the other side. But it does sound like we'll try this and see how it goes. But it may in the end be that someone whose last name is not Parikh and not Thakkar and is not related to either of them might be the people running the restaurants. But the Thakkars and the Parikhs of the world benefit from those restaurants being profitable. So my timeline is your timeline. You guys bounce the proposal back and forth a few more times, one more time, you decide that. When you conclude, Mr. Cohen, you've gone as far as you're comfortable going. Mr. Knowles, you conclude the same. Send what remains to Ms. Niles. It may be one document, it may be 2 documents. I'll reconcile the 2 as I see fit. It may be one with conflicting edits, whatever it is, that's fine too. But I will jump on that. And my intention then would be to enter it based on having reviewed the pleadings filed in connection with the motion for injunctive relief. Mr. Cohen, anything else?
Thank you.
You're welcome. Mr. Knowles?
The entities, Your Honor.
I don't want to leave open the concern, the motion that Mr. Cohen filed about Mr. Knowles representing the LLCs. I know I need to resolve that. I feel comfortable for now tabling that until we sort out the resolution to the emergency motion. I guess I'm going to ask you exclusively that, Mr. Cohen, because you filed the motion flagging the concern about Mr. Thakkar having retained Mr. Knowles to represent the 3 LLCs. If we put that on hold for now, get this order in place, does that work for you?
I think so, Your Honor. There's nothing actively happening right this minute.
Okay, good. All right, that's what we will do. As always, you know how to reach me through Ms. Niles. But again, outreach to Ms. Niles should be focused on, hey, I've got a question, as opposed to just want to let you know these other bad things are happening in this case. Yes, sir.
There's one thing that is actively happening, and that is the LLC defendant's motion for summary judgment. In the file, I think we have a response due on Monday.
Sorry, I didn't hear you.
I'm looking, hold on. It's a long docket. Just July, so many things filed.
I'm just gonna ask that if we,
If you're focusing on something else, could we give you a little more time? Let me look.
We would give an extension. Yeah, so. we didn't-
So October 1. Okay, is when this motion for summary judgment was filed. It may relate back a day or two. I think there was some issue trying to file it. But anyway, this is the one you're referring to, Mr. Cohen?
It might be next Monday.
Yeah, I think you have a little bit of time, but either way, I think your attention is better spent on what we talked about today.
And we have no objection, Your Honor. You might not care if we have an objection or not, you give it anyway. Just for the record, we have no objection.
Okay. Oh, phew, there's a brief. I was reading your motion. I'm like, how on earth could I rule on that? Oh, 40 pages. Okay. Yep.
I will note, Your Honor, the summary judgment is in the name of Green Chilies also.
Sure. So you're in either way. And you want an oral hearing? Yeah, so it was filed on October 1. So you've got until, I won't do the math for you, but yeah, Halloween, day after, that kind of thing. If you want to, I won't be ruling on it right away. So if you want an extra week or two to file a response, that's fine. If things don't evolve in a direction where the parties file something jointly saying, let's just stay the motion for summary judgment because X and Y and Z are happening.
I'll take 2 extra weeks if that's on the table.
Okay. All right. So just so we're clear and we're on the record. So we'll say November 15th. It looks like it's probably due November 1. And we'll just say have until November 15th because I find it is a more productive use of Mr. Cohen's time to see what progress can be made on a consent order or something approaching a consent order in connection with the emergency motion you file. All right. I think that's it. Anything else from you, Mr. Knowles? Mr. Thakkar?
No, sir.
Appreciate everyone being here. And I will look for the 1 or 2 proposed orders through Ms. Niles. As I said, it's your timeline. It's Monday, it's next Wednesday, it's whenever you all have pushed as far as you want to push it. Okay. Thanks. And you'll settle up with the court reporter? Good.
I think we've already worked it out.
All right. I just always say that so that the poor court reporter doesn't say, Judge, they ran out of the room. All right. Thanks, everyone. No, apparently you just need to find Mr. Cohen's secretary and then you'll get paid. Yeah.
Actually, before we guys leave, I just want to make sure that I have this spelled correctly. Like chilies? That'd be great.
Then we got that all.
Thank you.
It's actually my first trip to the house. Pandemic, everything I've done, but it's the first time. Hopefully, I don't see more here.
Well, welcome back to the courthouse.
Your Honor.
We are open for business here. Good. It works real well. I've done 4. And it's just you, I mean, your client may be there, but you and opposing counsel, that big screen is what the jurors are on. And when you're doing the individual voir dire, boy, you see the juror much more closely than you would if it were normal times. The jurors very much appreciate it because they are where they want to be for that real long day and boom, they're down here for the trial. So it should go well.
Make a motion to have one of the seats things to tell somebody some of the truth. It's great.
Too technical for me.
Vin Patel,
Sorry?
Vin
V,
Patel.
V-I-N, V like in Victor.
Okay,
I believe he's on there too. So
Okay.
it's the nod.
oh, yes.
Can you spell Chelios though? You said that name a lot and
Yes. E-L-I-A-S.
Thank you.
Thank you. Up on the wall.
did they end up leaving that order with you?
Yes.
I will take that, please. Thank you. Thanks for your help today.
Have a good day.
You too.
Are you standing here for the plea as well?
No, they're not gonna be taking anything out.
Okay.
Hey, how you doing? Where's the defense? Defense.
Oh, I was here for another hearing, I'm
got you.
packing up, so I don't know.
I got you. Am I on Zoom right now?
Oh,
It looks like I'm on Zoom. It looks like my volume's on. Hey, everybody. Can I go ahead and change these first? You don't
I'm,
know anything.
no, I'm just a reporter, I was here for something else. Yeah.
How you doing today?
Good, how are you?
What he said, he said. You don't see it? Check your email. Are you handling the plea for us today, or are you about to get out of here?
I'm about to be.
You about to get out of here while you can.
Yeah, clear.
I understand, trust me.
And I was called in for something else, so.
You private or you work for the county?
Sorry,
Are you private or you work for the county?
private.
Yeah?
I work for a firm, but yeah, I work for a corporate.
Awesome, thanks. Good to meet you.
You too.
All right, yeah, can you open up that video and see, look at the dash cam video and see if this guy confesses to hitting his wife on the video on the dash cam. All right. I saw that. Yeah, I saw that. I saw that. You got Larry on map up already?
I do.
Larry
No, I
on
don't,
map?
I need it. I could get another key.
Thank you so much.
I'm trying to beat you in here. I'm trying to beat you in here.
Oh, no, I'm fast. Can't beat me. It's, who's next Thursday? No, Larry on today. I was talking to a security guard here at the courthouse. No, I can't. One resolved, two resolved. you know, yeah, the plea is the resolution. Yeah, anytime there's a plea, there's no more trial. But yeah, take a look at the body cam and text me and let me know if he admits to hitting his wife, okay? All right. Man, you know it ain't that cold out there.
Huh?
It's not that cold out there.
That's a little bit earlier.
It's not anymore.
Doesn't matter.
It's gonna be hot out there when you get out there.
Okay, you're wearing a full suit, so you tell me.
I think you're hot without it. I wasn't supposed to say that. Shit. I'm sorry. Okay, sorry. Sorry, I'm taking myself off. Sorry, Judge. Lawyers just say what they think.
Huh?
Lawyers just,
You just listen, so.
I know, right?
Yeah.
But you're gonna be burning up, seriously.
Say it.
You're gonna be burning up. It's hot out there. It really is. I was super hot out there.
Appreciate it, but I think I got it.
I'm gonna manage. I will be reaching out to you regarding I need a court reporter for some upcoming depositions and things like that. So I'll reach out to you. I really appreciate you. Yes, I will. Thank you. How's it going, brother? Pretty good.
Have a good day.
You have a good one also.
You got in custody, right?
Larry, I'm at, yep, I'm waiting for him. All right, awesome. Thank you. Thank you.
You know, the other deputy was back there?
I thought she went down. Yeah, she was.
Okay, you got me. What you want? I'm in it right now, what you want? Oh. Well, you want to complain somebody else, what you complaining to me for? You already trying to get forward, I'm gonna tell y'all, the news to you. So that's what I'm telling you. Did you not reach out? Thanks. Well, I was telling you. Thank you.
I'll see you Monday.
Okay.
All right.
Have a good day.
You going to church Sunday?
Yeah, I'm going.
Okay, I'll probably come Sunday.
Okay.
Okay.
Okay. You said, I don't need that much.
Oh, man.
Oh. No. No. Oh. Okay. Look, I gotta call this section.
Three? I don't know where his train just went though. He just in.
He's right, you guys have. Cool.
Okay, thank you.
Are you guys free?
Hello, how are you?
Dr. Governor,
Mm-hmm. I told you that.
oh,
Nice, we got time.
And what I was trying to do, get my day started.
I mean.
I'm not doing nothing. If you get, you got your work down there.
So I'm really doing, so we gonna hold,
First of all, no.
You have to
still
hold.
have time. It's not very far.
but by the time we come, they're gonna be three, so if I stay
Okay, so
any,
go ahead and.
if I stay any minute, you have to be over. So, but that thing on.
Well, we're gonna just say that because I gave you that candy that day. This is your. If you tell Sarah the quick question, I said, can you just stand by the real
She don't want to. And then she was like, you might know, it's, I told you, I'm gonna keep on her. She said, you go get him, work with her.
Okay, she said.
I believe it.
We're gonna get together.
But see, you want. Girl, it's your court.
It doesn't matter either one. Some people don't like to see the inmate. Some people do. I don't know.
I get, cause I want to get back in there.
What's up?
Wait. Yeah, right.
I'm gonna recommend it again. I said, yeah, I'm gonna do it again because it's a whole other conversation.
You gonna lose?
No,
You know you gotta do it again. You know you can say, yeah, come on.
no, when it's a different set of group of people, they gotta be rewrapped.
I like you already, girl, you might never get
Shut up.
started.
He come here ready to see him, he's ready to come out, you know what I mean? Like, I can't be in areas, so I ain't gonna.
Oh, you said it again?
I said, if he come back in here, ready to see him, I gotta go back there, if he gonna come out, you know what I mean?
No, I'm saying, oh,
He's gonna do
you
it.
got to see?
He just didn't want to see him, I had to go get him. Now he had to talk.
Okay, let me see. You gonna do it.
Oh, you gotta take a picture like that.
You working me all weird.
You being just right.
I respect how you do it, that's smart. All the parties that been here for a long time, they still have that new kind of 2000.
Good share.
That's what the white told me.
I just had to talk to the family.
I had- I'm ready to see what? I'm sorry.
Good afternoon, ladies. Just make sure your cell phones are turned off on silent.
Can I ask y'all something ahead of time?
Yeah, the whole pep talk on happened.
Where is it?
On the slide.
No problem. Okay. No, coming from home, coming down my ranks. See, no, you're right. I said, I'll be on the first. Yeah, go here. Maybe I should just stay beside her. No, I didn't even, what's she doing back there? I was on the phone, I was like, gotcha. I'm like, wait, what? No, this is my spot. That's a spot there. You know, instead of being on stage, like I feel, they can see the just feel like I'm trying to come over here. I was trying to be so you different. Well, I got to sit down a little bit and I. Be coming. I'll take it off. I think it's a lot on you. Be harsh. Jeffrey. I'm let you do that. Oh. I don't know what I'm supposed to be doing on the weeds. I don't know what to say. Like, what's wrong with these people? And that's what I'm thinking. And then I'm like, I shouldn't have to try. Once we go to them, got me sick that years. I had to go to the wedding, and nothing, I got that. That's how I know that, man. They have a table. Fire. What you doing? Fire. Fire. You were so good. Look at that. Yeah.
Have a good weekend.
All right. Here, all right, then position 39, section, Honorable Judge Robert McBride, presiding, court will now come to order.
Good afternoon. We have a ferry in here. No flying in the courtroom. You all can be seated. I don't have a Zoom link but there's something on the screen. Was Mr. Arnold planning on being here? Oh, he's back there. Great.
Oh, you cut off the live?
Hmm?
I saw the live on my computer when I was standing up there.
Yeah, well, it's on the screen there, but I don't have, did you have a Zoom link?
I did. Or I do.
Let me look. Maybe it just didn't show up right here. I don't have it. Can you share it? Please.
I could. It's not letting me into my computer. So I brought my personal laptop down here. So
That's okay. Let me send an email. Maybe I can get it.
I would say. Well, okay. I'm in a courtroom. We're here now, and Judge, I think he sent me an email. Can you forward him the link? Well, sound like he just got it. Yeah, with the judge just came out, Arnold was actually fine. Oh, did I text you? I text you about the end. I had one of my colleagues. I couldn't remember. I couldn't remember if I texted you. It's so bad. I was like, did I actually do it? Okay. I had my friend send me a picture. I didn't need to know the new charges because we. So I have it. You know, when you say that, all I do is click on the actual link that comes in the email. Yeah.
I got it.
Oh, he said he got it.
Oh, I'm already in. It must be the same one we had before. That's bizarre.
She said no, it's a different one.
Well, somehow this is on it. I assume it's who should be on it right now? I may be on my old